close the hearing in the appeal, putting on the application of UNISON and the Lord Chancellor.
My lords, my lady, it's my job to deal with the discrimination grounds. I've got, again, regrettably, a very short period of time in which to do so, so I will have to deal with some of the materials by just giving you the page numbers or referring to the arguments in our written case. But in summary, my lords and my lady, UNISON puts the discrimination challenge on two bases. Firstly, the requirement to pay a higher fee for Type B claims subjects women to a particular disadvantage, since they are much more likely to bring Type B claims than Type A claims. Secondly, the requirement to pay higher fees for discrimination claims, those forming part of Type B claims, discrimination claims, is intrinsically liable to disadvantage women because, for common sense reasons, they're more likely to bring discrimination claims than men. Stating the obvious, women are disadvantaged in the labour market as women, and by and large men are not. Both ways of formulating the claim, we say, are good in law. However, the first argument, that is, the requirement to pay a higher fee for Type B claims, subjects women to a particular disadvantage because they're more likely to bring them, is now more straightforward, given the findings in the Lord Chancellor's review. And of course, if your lordships and your ladyship find discrimination on that ground, it isn't necessary for you to go on to the second ground, though I will have to refer to it shortly, just in case. I invite your lordships and your ladyship to remind yourselves of the context. We are here talking about Type B claims that attract fees of £1,200 as against Type A claims that attract fees of £390. So the difference is very significant indeed, and we say women bear the brunt of that. I'll come to the meaning of indirect discrimination in one moment, but before I do so, I need to very briefly refer to the Court of Appeal's findings, but more particularly to the Lord Chancellor's review, dealing with the Court of Appeal's judgment in relation to what was described below as variant 1, that is, women are more likely to bring Type B claims. The Court of Appeal, as your lordship and your ladyship will have seen, found disproportionate impact, see paragraph 85, MS 289, found disproportionate impact, that in fact had not been challenged by the Lord Chancellor in the Court of Appeal, though it was at first instance, and that finding is not challenged here. However, the review makes much clearer the extent of the disparity, and it is very significant indeed, and for that reason, I just need to take your lordships and your ladyship very briefly to the findings. If I can ask, please, your lordships and your ladyship to pick up Appendix Part 5, MS 1866, internal numbering 1612. No, that is wrong. Sorry, I've got the wrong way round. The MS number is... Yes, it is 1866, but the internal numbering is 1612. Perhaps I got that right as well.
You
I
did.
Get that right. Thank you. So MS 1866, internal numbering 1612. Looking firstly at Type A claims, prior to the coming into force of the fees order. So first table, table 22, year to June 2000, Type A, 41% brought by women, 59% brought by men. So disproportionality in relation to A claims. That has continued in broad terms post the fees. Type B claims 47.53, moving to 50.50, although that appears to be because of a drop in women's claims, but more women claimants, but more specifically, Table 23 shows a very real disparity, looking at it from male and female, type A, type B. Prior to the fees, 53% men claimants brought type B, 47% B. Converse is true in relation to females. Indeed, the figures are identical, but just reversed.
They should be.
Yes. Sorry. And of course, the same for type B. So there is, we say, a very significant disparity, continues both before and after the introduction of the fees. That disproportionality is accepted by the defendant in the review. I won't take you to it, but MS 1821-2 and Appendix Part 5, 1567-8. It's described as relatively small. We say it isn't. As to the reason for the disparity, although that is not significant in determining whether there is disparity at all, it may be relevant to proportionality. The reason for the disparity is obvious, and that is many claims, a very large proportion of type B claims are discrimination claims, and they are overwhelmingly brought by women, since sex discrimination claims form the bulk of them. Come back to justification in one moment and the legal framework, but the second basis of the claim, variant 2, related to variant 1, but we say the requirement to pay higher fees for discrimination claims is intrinsically liable, it's in the nature of it, intrinsically liable to disadvantage women, because it is women who, as women, experience discrimination at work. I ought to say, just because it hasn't been picked up yet, and so your lordships and your ladyship have it, prior to the introduction of the order, the Lord Chancellor recognised in its equality impact assessment that 82% of sex discrimination claims are brought by women, so recognised the impact of bringing into the type B category of cases, sex discrimination claims. We see that at MS 1109.
Is that 82% of all discrimination?
No, 82%.
Or 82% of sex discrimination?
Sex discrimination claims. In fact, women also are the largest class in discrimination claims generally. And I'll just give you both page references. MS 1109, MS 118, so 318, and the internal numberings, Appendix Part 3, page 855 and 864, again recognised in the Equality Impact Assessment. Come back to when one tests the legality of the order in one moment, but what we do know is even at the time of the making of the order, the Lord Chancellor had the figures on those disproportionalities. As to the legal framework, very quickly, in the 19 minutes I have left, it's a good discipline.
We started a few minutes late, so you probably got...
Okay, I've got 21 minutes. I won't waste it by time telling. Firstly, in relation to EU law, indirect discrimination in the conditions imposed on an entitlement to compensation for work-based claims, come to the case, but such discrimination will violate Article 157 of the Treaty on the Functioning of the European Union. That's the equal pay guarantee. So discriminatory conditions in relation to entitlement to compensation will violate Article 157, in short, because it's treated as an indirect means of pay. Come back to the case law. Won't take you to that. Article 157, nor will I take you to the next reference, which is the Equality Directive. You'll find that at Volume 2, Tab 26, MS 2686. This is the Gender Equality Directive. You will see from recitals 8, 28 and 29, great weight is placed upon the need for judicial protection and effective remedies. Article 1 covers pay and working conditions. Article 2(1)(b) defines discrimination and does so in a much more flexible way than had existed under domestic law prior to the introduction of the directive, as I know your ladyship and your lordships are familiar with. And then I would invite your lordships and your ladyship to refer to Articles 17 to 18, which are contained within a whole section headed Defence of Rights, contents of which are probably self-explanatory. The definition of indirect discrimination has now been transposed into domestic law. See paragraph 145 of our written case. Article 14 provides for a no less flexible concept of indirect discrimination, very flexible, free evaluation of the evidence it's described as. C144, paragraph 144 of our written case. And if I may just take you to one case from the Court of Justice, the classic case, I might be said, Seymour Smith, which is at volume 12, tab 166. This answers, I think, a couple of the questions raised yesterday. I hope it does in any event. And that's MS 6296, volume 12, tab 166, 6296. Yep. This is the case, as your lordships and your ladyship probably very well know, where there was a challenge to an order introducing a condition that required workers to have 2 years' service before they could bring a claim of unfair dismissal, and thus claim an entitlement to compensation in respect of that claim. I only have time to read the held, but hopefully I can make some points about it as we go through it, and I'll give you the paragraph numbers that I particularly invite the court to focus on. Firstly, so looking at the held over the page, firstly, a judicial award of compensation for breach of the right not to be unfairly dismissed constituted pay within the meaning of 119, that's the predecessor to 157. That principle must apply more emphatically to compensation for discrimination, given the terms of the directive. And then 2, that where an employee has been unfairly dismissed, the conditions determining whether he was entitled to compensation, or she, probably more properly put, entitled to compensation fell within Article 119, but those determining whether he was entitled to reinstatement or re-engagement fell within Directive 76-207. Pausing there, 76-207 dealt with equal treatment other than pay. Those 2 forms of discrimination, that is equal pay and unequal treatment in working conditions, are now contained within a single directive, the Gender Equality Directive, that I referred you to a moment ago. So the same principles apply to both. Loss of pay, Article 157, discrimination in conditions otherwise, that is, discrimination in conditions concerning remedies otherwise, falls within the scope of the directive under the working conditions provisions. Thirdly, looking at the held, the time, this is to address a question I think asked by Lord Wilson, if I remember rightly, yesterday, but the time at which the legality of a rule, such as the 2-year rule, initially is to be assessed, so that when does one assess the legality issue, depended on the legal and factual circumstances. Accordingly, where the authority adopting a measure was alleged to have acted ultra vires, that is, the order is unlawful at the outset, in principle, the legality had to be assessed at the time it was adopted, whereas in circumstances involving its application to an individual, then one determines the legality at that point. Just as to how one establishes illegality in this context, continuing, it might be appropriate to examine whether at the time of its application the measure was still in conformity with community law. And within regard in particular to statistics, it might be appropriate to take into account not only the statistics available when the measure was adopted, but also those compiled subsequently, which were likely to provide an indication of its impact on men and women. And that it was for the National Court taking account of all the circumstances, etc. So in other words, legality, where one's looking at an ultra-vires issue, was it unlawful at the point of making it, is determined by reference to its legality at the point it was made, not at the point of its application, the point it was made, but one is entitled to have regard to and rely upon statistics later collected which bear on the question of its legality. And that's important because we now have the review, yes, which makes it even clearer. And then 4, that just deals with the disproportionality issue, makes clear, as I think is well known, that disproportionality can be established by reference to statistical evidence. That's probably, in most cases, the easiest way, and as it happens, we can do that here. As to the second way in which the case is put, that is intrinsically liable, I take your lordships and your ladyship, please, to one case again, one case only, Volume 3 of the Authorities Bundle. Tab 32, MS 2837. This is 2837. This is a free movement case, yep, under the free movement regs, and much of the case law on indirect discrimination is found in its earlier formations under the free movement regulations, because of course they've been part of the EU scheme since the outset, but the principles apply equally to gender discrimination. This concerned a welfare benefit. Workers were entitled to a funeral grant, but only if the burial took place in the United Kingdom. Third country nationals, EU nationals, Mr. O'Flynn in this case, an Irishman, said that discriminates against EU nationals and is third country nationals and is contrary to the principle of equal treatment in relation to free movement. And in identifying whether or not there was indeed discrimination, the court at MS 2857, yep, paragraph 17, articulated the test in this way. The court has consistently held that the equal treatment rule laid down in Article 48 and the regulation prohibits not only overt discrimination by reason of nationality, but also covert forms of discrimination, which by the application of other distinguishing criteria lead in fact to the same result. Ignore the citations and go to paragraph 18. Accordingly, conditions imposed by national law must be regarded as indirectly discriminatory, although applicable irrespective of nationality, affect essentially migrant workers, leaving the citations aside, or the great majority of those affected migrant workers, leave the citations in parenthesis, where they are indistinctly applicable but can be more easily satisfied by national workers than by migrant workers, or where there is a risk that they may operate to the particular detriment of migrant workers. And finally, paragraph 20, it follows from all the foregoing case law that unless objectively justified and proportionate to its aim, a provision of national law must be regarded as indirectly discriminatory if it's intrinsically liable to affect migrant workers more than national workers. And then at 21 makes clear it's not necessary to undertake a statistical analysis to find substantive disproportionality. It's inherent in the nature of the rule. And a rule that requires a higher fee to be paid for discrimination cases is inherently likely to disadvantage women for reasons which are obvious. The Court of Appeal, as I say, found disproportionality in relation to the first aspect of the claim, type B claims more likely to be brought by women. As to the second aspect, discrimination claims, higher fees, intrinsically liable to disadvantage women, held no. That was to impermissibly construct a subgroup. They relied on the case of Jones and Manchester. Don't have time to take your lordships and your ladyship to that, save to say it raised an entirely different issue concerning the construction of the pool under very old indirect discrimination law emanating from this jurisdiction, and in my respectful submission doesn't bear on the questions that this court has to consider at all. As to justification then, of course it's for the Lord Chancellor to establish that the discrimination inherent in the scheme is justified. So justification generally has been dealt with by Ms. Rose. Here we're concerned with justifying the discrimination. We say the threshold for justification is a high one because we're concerned with a violation of the principle of equal treatment.
But what you have to justify is the provision, criterion or practice.
And the provision, criterion or practice is to pay a higher fee,
Yep.
type B than type A.
That's what's got to be justified.
And that is what's to be justified.
So it follows, does it, that if the type A fee were £25 and the type B fee were 50, would that be discriminatory?
Yes,
Would.
unless it was justified. I mean, it may be, and I don't advocate this, but one can see that it might be more readily justifiable because it's a lower fee.
But
the discrimination...
Because what you have to justify is the discrimination, surely,
yeah,
not the level of the fees generally.
Yes, precisely, but the balancing exercise. But
I see.
But nevertheless, my Lord, you're quite right that the discrimination has to be justified, so it's the difference in fees that must be justified given its discriminatory impact.
I'm sorry, I'm not sure that is correct. Section 19 of the Equality Act requires that the provision, criterion or practice be justified, or in effect, that's what is justified. That's what has to be justified by considerations other than the protected characteristic and the disparate impact on the protected characteristic.
Yes, but it's the discriminatory nature of the PCP that must be justified. So the PCP must be justified, but it is the discriminatory PCP that must be justified. So the introduction of the scheme here doesn't require, we're not concerned with justifying the introduction of the fees order, we're concerned here with the introduction of the PCP, type B claims attract higher fees, because that's the PCP
so it's
that's
the
under
higher
challenge.
fees that have to be justified.
Precisely. So it's the discriminatory nature, so it's the PCP, because what we're concerned with is the discrimination, not the fees order overall, generally.
But in order to make good your case, don't you have to argue that type A and type B are alike?
No.
If they're different, is that difference justified?
It may be justified, but the justification exercise has to be gone through. So in determining whether or not that PCP type B claims attract a higher fee is justified given its discriminatory impact, one has to go through the ordinary proportionality analysis. Does it pursue a legitimate aim? Perhaps it does. I'll come to in a moment we say it doesn't. But does it pursue a legitimate aim? Is there a fair balance? Because it's discriminatory, there still must be a proportionality analysis applied to it. May be justified on the basis that type A claims are said to be shorter than type B claims and use fewer resources. I'll deal with that in one moment.
Was the point I was putting.
But that is a proportionality assessment. It's not that the two claims are different as a matter of principle. They both fall for consideration under the order. It goes to the question of proportionality, justification. And as to the first point, my Lord, that is, does that distinction pursue a legitimate aim? Does the requirement to pay type B fees pursue a legitimate aim? The Lord Chancellor's case is yes, because type B claims use more of the state's resources, or the Employment Tribunal's resources, we say that is nothing more than a budgetary consideration, cost, and cost, budgetary considerations, are not good enough where one is seeking to justify discrimination, and most particularly, or especially discrimination, connected to a suspect class, gender, not a suspicious class, a suspect class. I nearly said a suspicious class, but we're not suspicious, just suspect. Budgetary reasons won't establish justification. That's very clear from O'Brien. Not going to be able to take you to that now, but I will just refer you, please, to our printed case, if I can find the reference to it. Can you just find that for me? Just find it for me.
Well, find it.
Take you to it.
Tell us later.
But in any case, the principle is that an aim which is entirely dependent on budget, cost, will not suffice where what's sought to be justified is a discriminatory rule, or a rule that's said to be discriminatory. In any case, even if it could be articulated differently, in other words, even if that aim could be articulated differently, as no doubt the Lord Chancellor will endeavour to do, there are other factors, in addition to those relied on by Ms Rose yesterday, that are material to the justification exercise, the fair balance exercise, that the court must engage with when considering this aspect of the claim. Just for the O'Brien reference, can budgetary reasons justify discrimination? That's in our case, paragraph 152, MS 124, thank you.
And it's tab 8 of the authorities.
I'm grateful.
2275.
I'm grateful. So budgetary...
That's the Luxembourg, O'Brien, or the...
It's Supreme Court.
Supreme Court.
I can't remember if your lordship was in it, but I take it not.
I wasn't.
It's the part-time judges, fee-paid judges.
Yes, of course.
Do we get pensions? Happily, yes. So one day we may be able to retire. Who knows? Budgetary...
We've had the second bout of it just last week. Was it last week? The week
Yes.
Third bout, yes.
Third bout, yes, fine.
In any event, so budgetary reasons not enough, but even if it could be articulated differently, in undertaking the fair balance exercise, there are specific factors that I would invite the court to have regard to. Firstly, the impact of fees anyway is especially likely to adversely impact on women, leaving aside specific discrimination in the scheme because of their unequal economic position. If your lordships or your ladyship needed a reference for that.
You mean can't afford it?
Can't afford it, we earn less.
Yep.
So women are already disadvantaged because of the disparity in earnings. See MS 1348 or Appendix Part 4 1094. The impact on women is considerable. Secondly, there's been a very significant drop in discrimination claims. See MS 1874, Appendix 5 1620. Thirdly, gender equality is especially protected in EU law. Indeed, the elimination of discrimination is one of the EU's stated aims and forms part of the foundations of the community, as it was. See our case, core volume MS 119, paragraph 138 to 9. And something alluded to yesterday by Ms Rose, but of most particular significance in this context, the prohibitions on discrimination have a broader social function, both in EU law and domestically, and they always have a normative function, as it's sometimes described. They seek to affect societal change, and so are of great importance, not just to the individual concerned, but also for society generally. And those goals are undermined if there isn't adequate judicial protection. And finally, my lords and my lady, if UNISON succeed on their primary grounds, those are the grounds contended for yesterday by Ms Rose, that the whole of the scheme is unlawful, there isn't a need for the court to decide the discrimination issue. However, respectfully, I invite the court to bear in mind that if the order is quashed, the Lord Chancellor will have to decide what to do next, and if she chooses to introduce a new order, she needs to know that it shouldn't be discriminatory and that women matter, and the impact of the scheme on women is an important matter to have regard to. My Lord, 3 minutes past 10.
Thank you very much. Thank you, Ms. Moore.
My Lords, my Lady, first of all, thank you on behalf of the Commission for permission to intervene. As you know from our written submissions, we're only addressing the argument based on effectiveness in Article 47, but we endorse the case of UNISON in other respects. In a nutshell, our case is the same as UNISON's. The fees order interferes with the fundamental right of access to the tribunal, as well as vindication of the fundamental social rights and the directives, and consequently across time with achievement of the objectives of the directives. Secondly, the proportionality test therefore applies, both as a matter of Article 6 case law and even more clearly under EU law under Articles 47 and 51 of the Charter. See NIAT, Alicini, DEB, SCA, Star Storage, and so on. Thirdly, contrary to the Lord Chancellor, the relevant factors for this purpose are not restricted to affordability. Inability to pay is almost invariably a sufficient condition for infringement of the right of access to a court, but it's not a necessary condition. And I highlight the points raised by UNISON yesterday about the disproportionate size of the fee and the effect across time on legitimate claims. So, my Lords, against that background, we say that the Court of Appeal got the test wrong because it focused exclusively on inability to pay. It put the bar too high, and for the reasons advanced yesterday by Ms Rose, in light of the all relevant factors here, the fees order is disproportionate and systemically disproportionate. My Lords, I'm going to go very quickly through the cases, through some cases, both Strasbourg and Luxembourg, but then just to highlight some more evidence in relation to the relevant points on proportionality. We adopt, of course, UNISON's submissions in relation to the Strasbourg cases, which show inability to pay isn't the only factor. It's neither reflected in the language of the cases or in their application. See especially Niat, Kordos, Weissman, Dimitrov. And in Kakir, for example, the sums charged there were very small, between 35 and 410 euros. See Para 7 footnote 3 of the court's judgment at MS 4982, but the court didn't say anything at all about affordability. Its sole focus was on the proportionality of the sums claimed in relation to the work done by the state in enforcement and the positive obligation of the state to enforce judgments. In its case at paragraph 36, the Lord Chancellor relies on various cases of the Strasbourg court to say that the sole focus of the test is affordability. Those are actually cases where the European Court criticised the domestic courts, often Polish courts, assessment of evidence that applicants could not afford to pay a fee as part of its so-called review function, mostly finding that the applicants failed to provide relevant evidence or found that the applicants failed to provide relevant evidence. So the cases are really about two things. Either the state has improperly assessed whether someone can't pay, or the applicant has failed to provide evidence in accordance with their duty of diligence. And so that's the reason for the decisions. In light of the time, can I just give my Lords and my Lady the references
Yes, of course.
to the relevant paragraphs? Teltronic. Oh, I should say before, in all of the cases as well, the courts looked at other factors. And here are the references. Teltronic, paragraphs 60 to 63, MS 5372, Meritebian, Georgia, paragraphs 44 to 48,
Yep.
MS 510729, Jedamski in Poland,
What was that page number?
MS 510829.
18829, sorry.
29, yeah.
Thank you very much, sorry.
To TO.
No, I understand, thank you.
Jedamski or Jedamski,
Yep.
more pronunciation problems,
Don't worry.
63 to 65, MS 5216.
Thank you.
Polajowski, MS 5285 to 6. L-Klomp is the case where the claimant didn't provide evidence, as he should have done. That's paragraph 43, MS 5095. And there are two other cases which were dismissed for other reasons. Buzek in Poland, that's the case that's only available in French at 8111. But there the fee was minuscule in relation to the claim. It was in fact reduced to 150 zlotys, that is 35 euros, which amounted to 0.25% of the sum claimed. So, and the court also found that he could have borrowed that money from his parents, not surprisingly, without any significant effect on their standard of living. And the relevant references there, and it was his fault if he overvalued the claim. The relevant references there are MS 4978. Shishkov and Russia, cited by the Lord Chancellor at paragraph 38 of its case, MS 148, to say that even if you can't afford the fee, that's not determinative, in fact is nothing of the sort, because the issue there was whether the claimant had failed to comply with directions of the court.
What was the case called?
Shishkov. It's cited by the Lord Chancellor at 38 of her case.
Yeah.
And so the issue there was there an independent reason for the claimant not being given a hearing because he'd failed to accord with the directions of the court? See paragraph 31 for the relevant directions, MS 5332, and paragraph 121 for the court's ruling, MS 5349.
5349.
MS 5349.
Thank you.
So we say none of the cases support the propositions that the Lord Chancellor is seeking to derive from them.
Thank you.
The Luxembourg cases equally say that inability to pay isn't the exclusive focus. But just to outline how we put our case on Luxembourg, firstly, although two principles are engaged here, both effectiveness originating in Roux and the principle of effective judicial protection originating in Johnson and now in Article 47, they are so wrapped up with each other that in practical terms it's hard to disentangle them. And you'll see from our written case, we say we can find no decision where the application of one principle rather than another made a difference. There may be this small reason of importance, though. What the foundations of the two principles do illustrate is that EU law isn't just concerned with the individual right of access to a court, it's also concerned with a fait utile. It's also concerned, via the Roux principle, that the general standards in a directive should be given effect in a member state's law. And of course that operates here, because tribunal claims at once must respect the individual's right of access to a court under Article 6 and the common law, but equally they are pretty much the sole means by which the state is giving effect to its duty of giving effect to employment rights guaranteed by EU law. Secondly, in any case, Article 47 is a flaw. We can't dip below that. And where it is the focus, as post-Lisbon it increasingly is, proportionality is an explicit requirement. See section 52.1 of the Charter, MS 2705, as confirmed by the ECJ in Star Storage, para 49, MS 292. Third, EU law by Article 47 may never give a lower level of protection than guaranteed by the ECHR, but it may give a higher level of protection. See Article 52.3 of the Charter, MS 2705, the explanations, which as the court has repeatedly held must be taken into account, MS 546, and DEB at paragraphs 32 and 35, MS 2832. So if UNISON is right, Strasbourg is a trump card. EU law can't adopt a lower standard. But if a trip to Luxembourg is necessary, the Commission would submit that the EU law imposes a higher standard. And it imposes a higher standard because the Court of Justice doesn't look at access to court in a vacuum, but in the particular context of the underlying substantive EU laws engaged. And of course, I don't need to remind you that the realm we're in here is of fundamental social rights, that at EU level are given the highest level of protection. They're akin to constitutional rights, and correspondingly entail a very high duty on the member state to give actual effect to them. See Coote, which Ms. Rose referred to yesterday, and our submissions at paragraphs 17 to 21.
Thank you.
Insofar as you are going to be taken to the Court of Justice cases, I make none of them concern social rights. So they don't really address the fourth principle drawn from Coote, that where you're in the sphere of fundamental social rights, the protection must be especially high. But nevertheless, there's some guidance in approach given from them. Firstly, we have DEB. That's Volume 3, Tab 31. The relevant paragraphs are 59 to 61, MS 2836, where the court required examination of a cocktail of factors, including the importance of what was at stake for the applicant, echoing NIAT and Cordos, but which was not reducible to affordability. Secondly, Horizonte, which was a case in fees in the context of public procurement, and if I can just turn to that case, it's at Volume 3, Divider 33, 2836.
2836?
2836, it begins.
Yeah, 363.
Sorry, 2863.
63.
Common error. And if we can begin with the Advocate General's opinion. Here, Horizonte was required to pay a court fee in public procurement of €2,000. That is about £1,695. So not a million miles away from the fees payable in a tribunal. The relevant parts in the Advocate General's opinion, yes, Ginnin, an experienced Finnish Advocate General, he says at paragraph 34,
Yep.
referring to the Roux principle and Article 47, that in this case these two approaches largely converge, because Article 47, guaranteeing access to justice, is the means by which the courts give effect to the public procurement rules. In other words, a fair util of this legislative act coincides with strict observance of Article 47. So that echoes our point that you'll look at that both requirements chime together. On how he approached the court fee of 2,000, first of all, at paragraph 38, he said at the end of that paragraph, the amount of the fee is assessed in light of the particular circumstances in a given case is a material factor. He there cites Stankov, so it's quite, that's in footnote 28.
Yep.
So it's clear so far as the Advocate General is concerned that Stankov isn't a case about claims being brought against the state. It's a case about a fee being too high. At 41, and bear in mind this is a fee of €2,000, secondly, even if the level of the standard court fee seems to be relatively high, this finding must be balanced with the simple fact that public procurement is not social policy. In other words, highlighting that in social policy one would expect stricter rules to apply, and then goes on to say that we're looking at an area in which the minimum contract values are £200,000, and so you can expect an undertaking to have sufficient economic resources. That's not the world we're in. We're in a world where, as we'll see shortly, most of the people who go into conciliation have just lost their job. But notice too, he doesn't focus on whether or not Horizonte could afford the fee. It's about proportionality in the abstract in this particular context. And finally, in his opinion, at paragraph 42, he says, picking it up halfway down, also relevant in my opinion is the fact that the court fees are refunded if the applicant succeeds. For access to a court to be respected, there must be an avenue available to challenge decisions taken in a contract award procedures, even if not absolutely certain that the action will succeed. In other words, even if you're going to get your fee back, if the fee is disproportionately high, that can still operate as a bar to access to justice, unless you're absolutely certain you'll win. Well, the world we're in is worse than that, because not only do you not know whether you'll win, in the context of discrimination cases, it's often impossible to assess whether you'll win, and because of the lamentable position on enforcement, you know that even if you do win, you stand a less than 50% chance of getting your full award.
How much of the Advocate General's opinion was approved by the court? I see paragraph 40 was specifically.
Paragraph 40 was
referred to in paragraph 61, yeah.
Well, the court gives its usual truncated version, which is understandable when you vote on things sentence by sentence.
Yeah, I understand.
But you can see at 58, paragraph 58 of the court, its focus too was on the percentage of the value of the fee compared to the contract. Nothing about affordability, a proportionality test. At paragraph 64, it focuses as well that in this area it presupposes an appropriate economic and financial capacity. Contrast that with what happens in the tribunal. And at 65, it also focused on the fact the fee was reimbursed if you won. In this context, against a public body, one would expect to get the fee reimbursed. But in the tribunal, we're in a much different, very different situation. So that's Horizonte. There's one small indication of how the court might approach fees in relation to the social sphere, if I can call it that, and that's in Oceano Gruppo. It's volume 12, page 163. MS6, the relevant paragraph is MS 6151. Sorry, that's the start of it. The relevant paragraph is paragraph 36.
Thank you.
So what was the MS? 16?
Which is at
615.
6180.
Nice.
Yeah. 26.
26. I got every number wrong.
Or at least you're consistent.
They address the position, this is in the consumer context, of high lawyer fees, and they make the point, in disputes where the amounts involved are often limited, the lawyer's fees may be higher than the amount at stake, which may deter the consumer from contesting the application of an unfair term. In other words, echoing precisely this problem of proportionality of cost versus benefit, not affordability.
Yep. Thank you.
And you will note as well there that the court talks about whether there's a real risk in that case that consumers won't be bring claims, which I can't help but point out echoes Lord Justice Dyson's test in Hillingdon, which Ms. Rose took you to yesterday. Now, my lords, in the short time that remains, I simply want to highlight some points of evidence. Forgive me, and my lady, forgive me for skipping through these.
Understood.
But firstly, as the point we made at the start, the more evidence there is that fees deter good or reasonable claims, the more likely it is they will detract from a fait utile, and therefore the greater the justification that's needed. And in our submissions at paragraphs 17 to 21, we comprehensively, I hope, emphasise how important these rights are in EU terms and how correspondingly high is the duty of a member state to protect them. As to the evidence of the effect of fees on practice, so far we've only focused on the effect of the issue fee.
Yes.
But there is, of course, a hearing fee. And I can only give you the references to the evidence on that, but there's a later ACAS evaluation in 2016, which found that a further large chunk of claimants who brought claims were deterred by the hearing fee. In fact, 20% said they withdrew because the fees were off-putting, mostly they could not afford it.
What, between issue and hearing?
Yes. Yeah. So they get the notice for the hearing fee, and then they withdraw. And interestingly, 14% of employers said that claimants withdrew because of the fee. So there's an additional deterrent effect which isn't captured in any of the statistics owing to the hearing fee. And the relevant pages for that are MS 1976 to 8.
Thank you.
On inability to pay, there is a further problem of the remission scheme which is specific to claimants. Ms. Rose yesterday gave you hypothetical examples of a pregnant woman who's just lost her job, for example. But those hypothetical examples correspond with empirical reality. And if one looks in volume 4, of the, this is the ACAS evaluation again, at 1484. Sorry, I've got the...
This is 14, yeah.
MS 1484, page 1230 on the internal numbering. You will see there under paragraph 3.
1484 in part 5, then. The internal numbering.
What was internal?
Mine,
MS 1484, it's 1230.
1230.
Thank you. That's all. Yep, thank you. Yep, sorry to interrupt.
This is the survey of those bringing claims. One
Yes.
sees under 3.1, about 4 lines down, 88% were no longer employed by the organisation in question. And going down to the next paragraph, the majority of claimants reported their employment had ended just before the EC notification was submitted to ACAS. And that's mostly because were dismissed. See the page over. And in fact, at the time of the survey, only 63% have had a job. That's MS 1476 to 8. So in our submission...
The other number?
MS 1476 to 8.
No, the other number. The
12222, 132s to 4.
Good.
So one has the position here that claimants in employment tribunals are somewhat analogous to the woman in NIAT and Cordos. That is, they've had an income stream, they've lost their job, but in the long term that income stream has evaporated. So therefore, of course, they may cross the disposable capital threshold, they may not qualify for remission, but the long-term position is poor. As to the exceptional power to remit, I think my Lord Hughes raised yesterday that the wording of the guidance had changed to refer to no longer being realistically able to afford a fee.
Well, I pointed it out. It's a change, is it?
Yes, that changed in October 2016. And the October 16 version is in volume 6 at 1681. were the relevant pages, MS 1935. That was when the wording referred to not realistically able to pay a fee. We now have data, since that wording was changed, as to how many claimants were affected by it. And that is in volume 5, page 1626 of the internal numbering, or MS 1880 of the other numbers. And that shows exceptional applications granted between July 16 and the end of December 16. But you can see from the schedule it shows about a third way down when remissions were granted after the 7th. The first one is the 7th of October. So after October 2016. And if you go across 1, 2, 3, 4, 5 columns, you will see whether they were granted or not. And subject to the usual mathematical problems I have, we make that 12 yeses. So 12 exceptional remissions granted in the period October to December after the remission wording was changed to say could not realistically afford. In our respectful submission, it is having nothing other than a negligible impact on the problem here.
Thank you.
On the size of the award, you will have seen our submissions at paragraphs 42 and 43 on that. We make the point, yesterday Ms Rose emphasised many of the claims were very small amounts.
1626 internal.
Yep.
Yesterday Ms Rose drew attention to the fact that many of these small type pay claims were for tiny amounts. We make the point that many of them, of the small claims, are type B, because unfair treatment of agency workers, fixed term workers, detriment relating to discrimination, these are all type B claims. Working time claims for rest break, type B. So many of the small claims that give effect to fundamental social rights are not type A, they're type B. Finally, enforcement. The Lord Chancellor accepts in his case, see paragraph 72C, small Roman 3, MS 161, that refund of a fee is a material consideration under EU law. The data from BIS, the 2013 survey, that was introduced just around, that was published just around the time of fees, is in volume 6, page 1726 of the internal numbering is the page I want to refer to, MS 1980.
Yep.
And here you see the record of who gets paid, both the total and depending on the amounts that the tribunal awarded someone. And one sees that the people who were paid in full, which are the first two columns, both those who didn't use enforcement and those who did, only 48% in total were paid in full.
Yeah.
Now that means only 48% on the evidence before the Lord Chancellor are going to get their fee back.
Understand.
And I won't take you to the other evidence, but you can see across each categories, there are people, for example, who've been awarded £2,000, stand a 50% chance of being paid their full award, and therefore a 50% chance of getting their fee back.
I suppose it depends how you look at it, but quite a few of the paid in part could, in a sense, have made, as it were, a profit, in the sense that they could have got a sum which equal to the fee plus some of their money. I'm not saying it's a complete answer, but the 15% in that category are in a grey area.
But when the Court of Justice is talking about it's a relevant consideration,
Right.
you get your fee back, they don't mean you get an award that you fund your fee out of.
No.
They mean you get your fee back.
I see that, but all I'm saying is that there's 48%, there's 15%, and then there's the balance. The 15% is slightly grey area, but I see your point.
So we say, in effect, the claimants here are the guarantors of the system. If they lose, they pay a fee.
Yep.
If they win, they don't get their fee back.
Yep.
And it's interesting to note that the respondent doesn't pay a fee if they lose and the claimant's awarded remission. So if a claimant who's got remission wins a case, there's no power on the tribunal to order a respondent to pay a fee. So respondents, we say, benefit every way here. Claimants are penalised every way. And my lords and my lady, my time is up. We've dealt with the burden of proof in our submissions. Can I just say this? The Advocate General in Yaskinan, in Horizonte, recognised the importance of people being able to bring claims when they weren't absolutely certain. In relation to discrimination, the rules on the burden of proof at EU level presuppose that often a claimant will not have all the evidence in their hands. If someone's not been promoted for a job and says they think it was because they were a woman, in the absence of the evidence, they have very little to go by. Ask, if all you were asked to advise on it, your answer would be, I don't know until you've got the evidence. So we say those rules too have a particular chilling effect. My lords, unless there's anything else, and my lady.
Thank you, Mr. Ford. Thank you. Mr. Barr.
My lords and my lady, until the introduction of the fees order in July 2013, the taxpayer wholly financed both free ACAS conciliation and free access to the employment tribunals and to the EAT. The principle behind the fees order is to alter that position to the extent of recovering a contribution towards the cost of running the ET and the EAT. The secondary aim is to increase the effectiveness and efficiency of the system by incentivising alternative forms of dispute resolution. The thinking is that the requirement to make a financial contribution to the cost of the claim will increase the incentive to seek to resolve workplace disputes, either in the workplace, through conciliation, or through other forms of alternative dispute resolution. ACAS conciliation remains free. It is now, however, mandatory to notify ACAS before presenting a claim, but it's not mandatory to enter into conciliation having notified. The intention is that the requirement to pay a fee to bring a claim in the ET incentivises a serious effort to conciliate.
By whom?
By both parties. By the claimant, because the claimant will have to pay the fee, and by the respondent, because if the respondent fails to engage and then is ordered by a tribunal to pay the remedy, they can expect to have to reimburse the fee. So,
but if you know that if the employer realises that the employee can't afford or doesn't make rational economic sense for him to bring a claim, then a rational employer will dig his heels in.
We submit, first of all, that if the claimant cannot afford, the system will provide for that through the remission scheme, failing which the exceptional circumstances safety net.
And I think my Lord's question is that employers can calculate that people who will not be entitled to remission may nevertheless be deterred. So far as incentivising the respondent to engage with the ACAS, if he's worked out the implications of the scheme, he will realise that the probability is, or at least the distinct possibility is, that he has more to gain by not engaging with ACAS.
But the employer who does that runs the risk that the claimant will pay the fee and then he'll have to reimburse it.
Well, I think that doesn't address the premise on which the question was put.
It's more rational if you've got a defence to a claim to explain that to the conciliator.
What evidence have we about the greater or lesser or entirely the same willingness of employers to engage with ACAS before, after the...
The early conciliation scheme is new. It was introduced after the fees order. We do have some information which I'll come to as to the precise statistics for claimants and respondents who don't engage. There's a slightly higher proportion of employers that don't engage. I disagree with the adjective that my learned friend Ms. Rose used yesterday about that. I'll come to the statistics. It's, I think, about 10% of employees fail to engage and a slightly higher percentage of employers.
Am I right in thinking that there always was a conciliation scheme available?
Yes.
It was just that the requirement to notify ACAS was introduced.
There has always been some provision to conciliate pre-action. My lady is right, and if there are any statistics in the bundle, I'm sure my diligent junior will dig them out whilst I'm speaking. Early conciliation has proved to be a success. ACAS believe that it's led to 48% of claimants avoiding the need to use the ET, and that figure is based on them either having reached a settlement as a result of the conciliation or having told those conducting their survey that the conciliation helped them to make their mind up not to pursue a claim.
That's a success, is it? It's a success from your point of view. Is it a success from the claimant's point of view?
Well, if the claimant has come to realise that they don't in fact have a valid claim, then that is a success.
Yes, but can you draw that conclusion from the raw statistic? I mean, surely a much more refined examination of the statistics would be required in order to support that conclusion. It doesn't follow necessarily that because after the ACAS engagement, someone withdraws, that they have been convinced of the futility of their claim.
ACAS may have said to them, look, your claim's only worth a small amount and you'll have to pay this enormous fee if you go ahead with it, for example. That wouldn't really count as a success, would it?
As I'll come to when I deal with the part of the ACAS study which my learned friends rely upon, it doesn't give all the answers that at this level of forensic examination one would wish. But one can say that far more people are now using early conciliation because it is mandatory. I think it's 31%, we'll come to the figures in due course, are successfully resolving their dispute, and 17...
No, they're resolving their dispute. Let's not use the word successfully. The dispute is either withdrawn or they've got something out of it.
It's more than withdrawn because there are people who...
Either withdrawn or they've got something out of it.
And, of course, it's very difficult to...
It may not be what they're entitled to, but they've got something.
But that will always be the case with alternative...
It will indeed. It's one of the disadvantages of alternative dispute resolution.
What proportion of cases don't proceed after ACAS negotiations compared with what proportion of cases fail at the tribunal?
I don't have that statistic at my fingertips. More work for my diligent junior.
May or may not be available. Forgive me, you said earlier, I must have misunderstood you. I thought what was mandatory was to notify ACAS.
Yes.
But I think you said that it wasn't actually mandatory to engage in the conciliation.
Yes, and a certain percentage of employees and a certain percentage of employers.
So it's not mandatory conciliation, it's mandatory...
Notification.
Notification, and therefore being given the opportunity.
Yes.
Well, I'm relieved to know that, but because that's the situation in family cases as well.
When you notify ACAS, they then write back and say, we offer this service today.
I believe so. There's a conciliator. They refer it to a conciliation officer, and the conciliation officer gets in touch with the party.
Can I help you, effectively?
Yeah, and offers a service. And if the employee says yes, then the conciliation officer approaches the employer. If the employee says no, it stops there.
Yes.
At all times, it has been and remains the intention of the Lord Chancellor to achieve the aims behind the fees order whilst maintaining access to justice. She doesn't accept that a person who can afford to pay a fee specified by the order but chooses not to do so is being denied access to justice.
If the fee is on a sensible basis, renders it uneconomic or not sensible to proceed, even though you can afford it, does she accept that that is a denial of access to justice?
I'd like to attack the premise, if I may, in that obviously if you have got a good claim and a solvent respondent who can repay the fee, then that is very important to the calculation.
A good claim begs a whole lot of questions. You're judging it at a stage when you're deciding whether to issue proceedings. You're not judging it in retrospect.
Well,
anybody who's advised people in any field knows a good claim can mean all sorts of different things to different people, and there's virtually never a certainty of a good claim. You're taking a chance. It is, in a sense, a gamble.
Everyone who has to litigate, whether in the courts or now the tribunals, has to think about the fees. In courts, they have to think about costs as well. In the tribunals, before fees, they had to think about time, trouble, and there are all sorts of other forms of expenses. They have to make a calculation about what's at stake, what their prospects of success are, and whether they'll get the feedback.
As the interesting paper Ms. Rose took us to, that does suggest that there could be cases, common sense would suggest there would be cases, where the amount at stake means that even if you've got a good prospect of success, economically, it's not sensible to proceed because of the fee. Do you accept that if that is such a case, that is a denial of access to justice?
I don't accept that, because if the prospects of success are so low that it's not sensible to bring a claim, that's not a denial of access of justice. If what can be gained back from the employer has to be taken into account, and I don't accept the premise that there are cases where the calculation is such that it's not worth the candle.
I suppose what you could say is that if there was no fee chargeable, then a certain case may be worth pursuing. But there must be cases where once the fee goes above a certain nominal level, it will turn it into a case worth pursuing to a case not worth pursuing. And if there were an absolute rule that if any case could be put off because of a level of fee, you couldn't have any fees.
Yeah, that is true. And I also submit that there is a distinction between someone who's being prevented from accessing justice and someone who's being deterred. And I say the test for access to justice is whether you are being prevented. And at the extremes of the examples we're thinking about, it's whether the calculus and the risk becomes unattractive. And I say that's not prevention. Decide whether to take the risk or not.
Yes.
But ultimately, what is the test you advance? Do you accept that we're in the field of proportionality here, forming a judgment, using that word if we use any word, or is it a question of prevention, unaffordability?
I accept that, as Lord Justice Underhill found in the Court of Appeal, there is an element of proportionality. But in this context, it's not the classically structured proportionality test with all factors bearing equal weight that my learned friends press upon you, what it boils down to in the circumstances of this scheme is, in practice, whether it is affordable. That is the preeminent factor. If it is affordable, then it is proportionate. And when we go to the Strasbourg cases, the premise of those cases is if it's unaffordable, then the court finds that the essence of the right has been impaired and it's disproportionate. There are cases where there's an additional barrier. For example, the irrecoverable fee, even if you've won the case, and so on. And it's only where there's some additional prevention of access to justice that you can have an affordable fee. And so I say, effectively, in these circumstances, the test collapses down to, is the fee affordable?
The approach, the word Lord Justice Steyn used in Leach was impediment. And if you recall, the Court of Appeal disapproved of the approach that the Scottish judge had taken at first instance in saying that there was no breach of the principle of access to justice merely because the prisoner was prevented from corresponding with his lawyer because his lawyer could always go and visit him. And the Court of Appeal said that wasn't the correct approach, that preventing correspondence was an impediment with access to justice.
If I recall correctly, but that was on the premise that there were some cases where the solicitors, for all practical purposes, would not be able to go on the visit because the solicitor and the client were so far away. And I do say there's a danger of extrapolating from a very different factual circumstance any wide-reaching proportionality test, which I say you can't do from Leach. I submit that, in fact, properly analysed Leach is really a statement of the obvious. There's a fundamental right to consult one's lawyers, and through correspondence, LPP is of paramount importance, and all the state can do is prevent it being abused. There's an obvious risk of abuse, and therefore the limit of the power is to check whether or not a communication is bona fide. And that, I submit, is a million miles from where we are today, both in fact and legal principle.
A better word really would be barrier rather than impediment.
Well, absolute barrier, I think. If there's an insurmountable obstacle, I say that is denial of access to justice. Hence, if it's unaffordable, there is a denial, and that is what the scheme is designed to prevent.
I mean, that's putting it very high. I would accept that I think impediment itself has a slight hint of unjust impediment or excessive, but unsurmountable obstacle sounds like a very high barrier indeed. Unaffordable seems to me slightly more qualified, but all these are just words ultimately.
Quite important ones. I say an important feature of the scheme is that you can get the fees back, and in due course I'll take you to one of the cases which shows that in practice the fears that my learned friends have expressed that you might not get the money back are ill-founded. If you have won either in whole or in substantial part, the case law shows, insofar as there is any, that you will get the money back, rather like costs following the event in the civil courts.
That you'll get the money back, or that you'll get an order?
You get an order.
Okay.
And when we come to enforcement, obviously that can be important, but there are special reasons why you should be cautious of the statistics. The choice of approach was a result of a detailed consultation and impact assessments I will later in my submissions take the court to those documents and explain why the system was structured as it has been in this jurisdiction, the reasons why alternative approaches were rejected. And I submit that's going to be important, because what my learned friends haven't done is really posited alternative schemes. There are serious disadvantages to the alternatives, not least to those who might wish to bring discrimination claims. The operation of the system has, as you know, been reviewed. The Lord Chancellor is troubled by the substantive drop in claims, and subject to consultation, is proposing to adjust the remission scheme in order to alleviate the burden on those with the least disposable income. That, as we'll come to see, was initiated by the duty under the public sector equality duty. It's not something we say we were required to do in order to ensure access to justice. We submit that was already being guaranteed, but there are other reasons to make the scheme more generous and see what effect it has on the drop in claims. I'm proposing to deal with each of the three grounds in turn. In relation to ground one, access to justice, I'm going to deal first with the Strasbourg case law myself, and then my learned friend, Ms. Wakefield, is going to deal with the European law. So, turning first to the Strasbourg case law, which is the most developed on court fees, and that is why I turn to it first. We have prepared a table overnight. I say we, the credit goes to my learned junior and a pupil from her chambers, Ms. Mockford, who is sitting in court today.
It usually does.
Indeed it does. What we've done, because the cases are not in the bundle in chronological order, we've set them out in chronological order with observations with a view to truncating the submissions and assisting the court's rapid understanding.
So you've got them there for us, have you?
I thought they were handed up this morning, my lord.
Oh, are they? Yeah. Mine's just such a mess. I haven't even missed them. Okay. Right. Thank you. That's very kind. Thank you.
I submit that the case law demonstrates that the Strasbourg test, whilst referring both to the need not to impair the very essence of the right and proportionality, in practice doesn't show the court conducting a bifurcated test. Of course, because it's Strasbourg case law, we're looking for clear and consistent lines of decisions and not the outliers, of which there are some. But the starting point on which there is a clear and consistent line is that a court fee per se does not violate Article 6. You can see that from Kreutz at paragraph 59.
One notices the words including the applicant's ability to pay in the quote at the bottom of the page.
Yes.
Which suggests that's not the only test.
It's in the context of balanced against the amount of the fee and the stage of proceedings at which the fee is levied. Those are the three features which are highlighted in the Kreutz formulation. I submit that the other consistent reference you see is the need to submit purely financial restrictions, such as this one, to particularly rigorous scrutiny. I don't shy away from that. My lord...
It looks again, if one looks at the quote at the next page, in the same case, the last quote from the case, it looks as if deterrence is the test, resulted in resisting in its claim. That, in the court's opinion, compared the very essence of his right to access.
Well, if you've
That is, that was a case where the fee was simply unaffordable.
Well, I'm looking at what they said, yeah.
Well, that's a statement, isn't it, of the effect in that case,
Yes.
which
Yes.
is scarcely surprising if it really was a year's income.
Yes, and more to the point, he didn't have it. I can take you through some of the more details, but I say that when you actually look at the facts,
Yes.
you see that in practice they hold as a breach either if the claimant couldn't afford or if there's some additional factor which constitutes a barrier to justice. So there are cases which at first blush might appear to involve fees which are literally affordable, but they are all cases in my submission with a special feature. If and insofar I'm wrong in that, there's certainly not a consistent line of authority to the contrary, and there's certainly not a consistent line of case law which begins to support the analysis advanced by my learned friends. There are plenty of examples of the simply unaffordable cases. That might, starting with Kreutz. In that case, he did in fact have some assets, but he wasn't able to dispose of them. And he didn't have the 100 million zlotys, which constituted the fee. The same can be said of Podbielski, where the applicant simply didn't have the money, and Polojowski, where the fee was 20 times the applicant's documented monthly income. The reference to that is Bundle 9, tab 125, paragraph 26. There are some cases in the category where the fee is prima facie affordable, which I need to deal with. The first is NIAT, raised by my learned friend Mr. Ford in his written submissions. Yes. But the answer to that is that the court said that it was not reasonable to expect the divorcee appealing the divorce to use the divorce settlement because it was required to fund her basic living needs and those of her children. And the reference for that is it's Bundle 2, tab 20, MS 2617, at paragraph 44. And I lay emphasis on the word basic. The same can be said about Sibiki. That's Bundle 8, tab 113, at paragraph 32. Kordos.
Oh, wait a minute. It says rather than build her future and secure her and her minor children's basic needs. So it's building her future as well. Slightly unfair to say it's purely basic needs, isn't it?
What it is, in effect, is a case where the court is deciding that there's a special reason why a lump capital sum should be excluded.
Yeah.
That's what I say essentially is the analysis.
Yes, I understand that. Yep.
The phrase unaffordable does not express an absolute value, does it? In other words, something is affordable depending, among other things, on your other needs and wishes.
Yeah. There is the question is what is unaffordable?
Yeah.
And had the challenge been mounted by a real person, the facts could have been examined. As it was, the claimants have relied upon hypothetical comparators, and for reasons which I'll come to in due course, my submission is
right. But when you say that the test is simply unaffordable, you're not saying that that is an absolute standard?
It's unaffordable, obviously, on the facts of the case. And that's why the remission system has a bright line rule, because lots of people apply with an exceptional circumstances safety net.
Who is to make the judgment as to whether a claim is unaffordable? Is that something to which the claimant may make a contribution? Well, by saying, well, these are my other needs, these are my wishes for expenditure, and I regard it as unaffordable.
It's not a subjective test. It's an objective test, which is based, first of all, on whether someone fits within the terms of the remission scheme, failing which if there are exceptional circumstances, then at that point, somebody can explain why it is, even though they don't fit into the remission scheme, that an exception should be made. So
affordability reflects a lack of entitlement to be included in the remission scheme, plus an absence of exceptional circumstances. Is that right?
I beg your pardon, my lord?
Yes. I've understood from your answer that unaffordability in practice means you don't qualify for remission and you're unable to demonstrate exceptional circumstances. Is that right?
And you can't afford, and you generally don't have the money to pay the fee.
Yes, but that's what I'm trying to get at.
There'll be lots of...
How is that determined? Because an individual has many needs or many demands on their expenditure. Yeah. I mean, how is that question of not having the money to be determined? I mean, well, you can go to a bank and use your house as collateral, or use whatever assets you have as collateral. You might be said to be able to afford it.
Well, there's no requirement to borrow to meet the fee. There is obviously a disposable capital test, and my learned friend showed you yesterday that the threshold for most of the fees in the system is you need to have disposable capital of less than £3,000 if you to proceed through the remission scheme. The numbers in the remission scheme and the thresholds were set initially, I think, with regard to thresholds that we used elsewhere in the system. And the current proposal is that the fee thresholds will be increased to what is effectively the national living wage.
Yes.
And
with reference to what was the £3,000 set?
Sorry, no, I was talking about the threshold, the income
yes,
threshold.
I understood that, but I was
the disposable income threshold. I may need to take instructions on that.
It's the capital one that
I don't think that was pinned to any particular measure.
No, nobody asked what a layette normally costs or anything like that. And given we're talking a lot of cases which do have to do with women who are dismissed in circumstances of pregnancy.
The provisions are such, the rationale in the consultation document is that if someone has got a lump sum of redundancy money, then it's right that if they can afford the fee, they should use that. In relation to a pregnant woman who is dismissed, then they'll have, unless they're given a lump sum with the dismissal, they'll have no income. And so unless they've got savings over £3,000,
well, that's why I'm asking you.
Pass.
What was the rationale for the £3,000?
I'll take instructions on that.
Thank you very much.
Were we told that it was the same for other fee systems?
Yes, it is. It's the...
But that doesn't answer the question where it came from, of course.
Yes. The last of the three cases where I say that effectively some form of capital has been ring-fenced by the Strasbourg Court is a fatal accident case where the...
Sorry, which one was that?
Cordos It's at bundle 9, tab 121, and the material paragraph is paragraph 36. I don't think we need to turn it up, but the point is that this was a compensation which the widowed person had received,
Yep.
which the court decided ought to be ring-fenced. And of course, in the current remission system, that sort of payment would also be ring-fenced.
Yes, I see. Thank you.
The post-trial fees or costs cases are a little different because of the stage of proceedings at which the fee is levied. And a striking feature of those cases in my submission is that they're often cases where the claimant has already won and established a meritorious case, but is denied the remedy either because they can't afford to initiate enforcement proceedings, which was the situation in Apostol, or because the system means that they have to bear some cost, which means they're effectively denied some or all of their remedy. So Stankovic, where despite being successful, the claimant had to bear his own costs despite having acted reasonably, is such a case. And Stankov, similarly, where Stankov had won his case but had to pay 90% of the damages in a court fee. So the special features there are denial of justice through an ex post facto denial of remedy, either in large part or in whole. The Stankov case, I would pause to observe, shows the perils of a system which requires the applicant to value a claim in advance. And one of the reasons why the Lord Chancellor didn't introduce such a system in this jurisdiction is because in a tribunal which is supposed to be informal and where there are causes of action which are difficult to value with accuracy, that could result in problems of people paying the wrong fee, which was what happened to Stankov. The most extreme example, I think, in the Strasbourg jurisdiction of this problem is Perdigão, where the result of the regime in question, it's an Article 1 protocol case, but the result was the winning party had to pay 15,000 euros more than they'd recovered in the court fee. That's Bundle 9, tab 124, paragraph 69.
Yep.
There are other less dramatic, exceptional features of cases. In Marina and Latvia, at Bundle 14, tab 191, the problem was that the court had made repeated conflicting decisions, and the Strasbourg court simply decided it was unreasonable to make her go through the remissions process once more, and so didn't actually decide whether or not she was impecunious. My learned friends relied on the Weissmann case, the striking case of the people who regained possession of the German embassy in Romania. But in my submission, it's far from clear from the wording used that this is not an unaffordability case. It does talk in terms of the claimants being obliged not to pursue the claim, and it does refer to their financial circumstances. And we are not told what the position is and whether the claimants were able to obtain any liquidity from the property which they had recovered. One does see in the case law a trend that mere discouragement is not enough, and I submit you can see that from the eye-watering fees in some of the cases which don't prima facie cause the court to bat an eyelid. We've referred many times to Kreutz, a year's annual salary, Jajamski and Jajamska, 50 times the average monthly salary, and perhaps the most extreme case, Butchek, where the answer was the claimant was expected to borrow from his parents to fund the claim. So it's not a line of jurisprudence, I submit, that assists my learned friends. It's now time for me to hand over to my learned junior to deal with the European Union law.
Are you not going to deal with the ultra vires argument that
Yes.
Rose developed?
I was going to come back to
You're going to come back to
the
it.
domestic law and later to ground two.
Okay.
My lords, my lady, I'll be addressing you on EU law as it arises in the access to justice argument. Miss Rose dealt with EU law on court fees in very quick fashion yesterday. I'm going to address it in a little more detail today. I say it helps me and doesn't help her. In overview, I'm going to start by saying a few quick words about the principle of effectiveness, which is, of course, how the case was argued below, and it is the ground of appeal on which permission was granted to this court. You'll find that at page 21 of the core bundle. The argument at that time was the Court of Appeal erred in its approach to the EU principle of effectiveness and imposed an impermissibly high threshold. And the case has obviously undergone something of a transformation since that point. Not only did EU law only focus for around 10 minutes of Miss Rose's submission yesterday, but of course she now doesn't refer at all to the principle of effectiveness and focuses entirely on Article 47. It's common ground, I think, that Article 47 is the baseline, so there's nothing wrong with that in principle, and that Article 6, ECHR, is the baseline for Article 47. And we know that not least because of Article 52.3 of the Charter, which is the provision to which Mr. Ford made reference this morning. Once I've said a couple of things about the principle of effectiveness, I'm then going to turn to three EU cases in particular: DEB, Horizonte, the only case actually which refers directly to court fees, and a case to which Ms. Rose didn't even make any reference in her three cases she referred to, and Star Storage. From these, I hope that your lordships and your ladyship will see that, firstly, the EU cases do not go further than Article 6, and secondly, in fact, they support our interpretation of the Article 6 case law. Horizonte, in particular, is a case in which the court notes the marked deterrent effect of the fees in public procurement litigation. I'll take you to that passage. Also takes into account the fact that the referring court was very troubled by this analysis of the rational claimant and the fact that actually the profit which a public procurement claimant was likely to make out of the contract was significantly lower than the value of the contract by reference to which the fees were set, and again dismisses that concern. Before I dive into that case law then, just a brief word about effectiveness and why this change in position matters. So first of all, what we mean by effectiveness isn't quite the same as what Mr. Ford said this morning. He referred to effet utile, and of course effet utile is a very important principle of EU law, and it's often translated by the word effectiveness. But the principle of effectiveness that was put to all the courts before, both divisional courts and the Court of Appeal, was the limiting factor on national procedural and remedial autonomy, in respect of which the classic formulation is virtually impossible or excessively difficult. Now, of course, the words virtually impossible have subsequently, as acknowledged by Lord Justice Underhill, been replaced by formulations such as impossible in practice, but the point remains that that fairly low-sounding bar, which exerts a negative pressure on what the national courts and national authorities could otherwise do, is the way it was put below. In contrast, we have the right to effective judicial protection, as protected by Article 47 of the Charter, as finds its roots in Article 6 ECHR, in respect of which any restriction on a right needs to be justified. Now, in the current case, and whenever when you're looking at court fees, you have those two principles overlaying on top of one another. And it's fair to say, certainly Mr. Ford and I agree, I think, that the CJU case law is plagued by an inconsistency in respect of how those two principles interact. Sometimes they're treated as entirely distinct. That's the case in Alicini. On occasion, effective judicial protection, so the Article 47 right, is treated as being subsumed into effectiveness. That happens in Horizonte, and we'll see what that means for the analysis. And on occasion, only effective access to a court, as enshrined in Article 47, is referred to. That's DEB and star storage. So does that confused picture matter for today's purposes? Firstly, it matters that we're cognizant, in my submission, of this confusion in order that we can properly understand the CJU case law. It also matters, in fairness to the Court of Appeal, so we can understand why their judgment was in fact right. Yes, they used language of impossible in practice. Yes, they used language of excessively difficult. But they referred almost entirely to the Article 6 case law, thereby pulling together these two separate strands of principle, effectiveness and effective access to a court. That's why we say they were essentially right. And it also matters because when we look at a case like Horizonte, assuming that we're all right in thinking that it probably doesn't really matter whether you analyse it under effectiveness or Article 47, that tells us something about what Article 47 means in this context. And so I will rely on Horizonte, which applies the principle of effectiveness, as indicative of what Article 47 means, and in turn, indicative of what Article 6 means. So with that introduction, I'll turn to DEB. Now that's in Authorities 3 at tab 31. So both UNISON and the Commission rely in particular on paragraph 61 of DEB. That's at page 2835.
Thank you. Yeah.
And Mr. Ford this morning referred to that as setting out the cocktail of factors which the court should take into account. You'll see there's reference to the subject matter of the litigation, reasonable prospects of success, importance of what's at stake, complexity of applicable law, and the applicant's capacity to represent himself effectively.
Yeah.
That paragraph is taken directly from the ECHR case law on legal aid. This was a legal aid case, and it's taken from the legal aid case law. And I'll make good that submission by turning back 2 pages, if I may, to paragraph 46, in which we see the CJU set out the very ECHR cases from which it takes those relevant factors.
Yep.
Airy, McVicker, P, Steele, well-known cases, setting out these particular factors. So in this case, in DEB, what the CJU is doing is exactly what we say should be done in the present case, namely regard should be had to the formulas used in the ECHR to inform the relevant factors to any particular analysis. Those factors, that cocktail of factors, applies to a legal aid decision. It does not apply to court fees. That's my first submission in respect of DEB. Now, my second submission...
It could be argued that it would apply a fortiori to court fees, because you can go to court without a lawyer, but you can't go to court without paying the fee.
That takes me on nicely, if I may say, to my next point, my lady. So DEB, in fact, was a case which was analogous in many respects to a court fees case. The legal aid in question was asked for to pay a court fee and to instruct a lawyer in a jurisdiction in which use of a lawyer was mandatory. And we see that comes into the analysis in the next sentence, in paragraph 61,
Yep.
See, in order to assess the proportionality, so that's after he set out the cocktail of factors,
Yep.
the court may also take account of the amount of the costs of proceedings in respect of which advance payment must be made, so that's the court fee up front, and whether or not those costs might represent an insurmountable obstacle to access to the courts. And on the facts of that case, the court fees were such that absent legal aid, there was no way that the applicant could access the court. In effect, it's a remissions decision case. It's analogous to one.
But isn't paragraph 62 dealing with legal persons?
It is. That is, in general, that's a point about DEB, that it may be that that's the reason why, despite the fact it was an insurmountable obstacle, nevertheless, the court was happy with the idea that perhaps that wasn't even sufficient, to use the language of Mr. Ford, and it was acceptable to have an entirely insurmountable obstacle because you're dealing with a legal person. I would accept that. Nevertheless, we say that the cocktail of factors, for example, subject matter of the dispute, importance of what is at stake, chances of success, these relate to a legal aid assessment and don't relate to an assessment for court fees.
In relation to court fees, all you're concerned with is whether it's an insurmountable obstacle? Yes.
Yes, my lord. DB can take us no further than insurmountable obstacle.
Yes.
Yeah.
Precisely. Thank you.
Because I don't say that it would be right to say the domestic court may simply take into account that it's an insurmountable obstacle. I would say that test could only apply to a legal person, and we would accept that domestic court,
yes,
it would need to ask itself, is the obstacle insurmountable? And if the answer was yes, then there would be a breach of access to justice. So it's not an optional factor in our case. Turning on then to Horizonte,
Yep.
which is in tab 33
Thank you.
of the bundle.
Yep.
So as I said earlier, Horizonte is the only case at the CJU level that deals with proper court fees pure and simple. And we see at para 26 of the judgment, which is at page 2885.
Yes.
The last sentence, that the referring court notes that public procurement litigation significantly decreased as from 2012. Turning to the previous page in paragraph 7, we see that the fees were increased in 2012, so that's the date of the increase of the significantly increased fees. And if we go to paragraph 24, there the CJU sets out considerations of the referring court. It says, it is concerned that the taxation of actions before the administrative court, especially as far as concerns the award of public contracts, may dissuade undertakings from pursuing their legal action and therefore poses problems for compliance with the criteria and principles of the EU legal order. The referring court presumes that the undertaking's profit margin amounts in general to approximately 10% of the value of the contract and considers that the advance payment of a standard fee exceeding the amount of such a profit may lead individuals to abandon certain procedural mechanisms. So arguments that are very similar to the arguments that are being advanced before your court. If we turn to paragraph 58 of the judgment, we'll see how the CJU deals with those submissions.
We looked at that earlier. Yep.
So, first of all, it anchors its analysis in effectiveness. It uses the language of practically impossible or excessively difficult. This case dates from October 2015. It's a recent case. It postdates the Court of Appeal, and that's the language it uses. On the previous page, at paragraph 48, we see that the court takes the view that the principle of effectiveness implies a requirement of judicial protection guaranteed by Article 47 of the Charter. So it believes that its analysis is complying with both principles. That's its intention. We don't then see a classically structured proportionality analysis. We don't see an immediate identification of the legitimate objective of the fees. We don't see an analysis of their appropriateness. We don't see an analysis of whether they are necessary, whether there are less intrusive measures. Still less the sort of Laffer curve, profit maximising economic analysis urged upon you by Ms. Rose yesterday. Instead, they simply say, oh, We think that those fees don't render proceedings practically impossible or excessively difficult, paragraph 58. And then they say, paragraph 59, none of the factors raised by the referring court or the interested parties calls that finding into question. And they deal with various factors in turn there, which I will seek to run through. So first of all, they deal with this argument about the fixing of the fee by reference to the value of the contract, the big public procurement contract that people were tendering for, compared to actually the profit. So what the rational litigant would take into account. And the court says, well, no, first of all, we're happy that many member states take the approach of imposing court fees by reference to the value of the contract. Fine. And then they say, paragraph 61, a rule requiring specific calculations for each call for tenders and for each undertaking, the result of which could be challenged, would prove to be complicated and unpredictable. And we say that's one of the various reasons why the idea of the rational litigant and that being reflected in a regime which imposes fees across the board, as opposed to, for example, a legal aid assessment, where I think my Lord Mance and my Lady Hale yesterday commented that in a fees regime, one doesn't make an individualised assessment. One doesn't say to a claimant, what do you think your chances of success are? Still less would one, as I think the logic would demand, impose lower fees the worse a party's prospect of success are, and higher fees for the person who's patently suffered discrimination. So they address that point. Paragraph 62, the argument there is that the flat fee operates to the detriment of economic operators with weak financial capacity. So that's effectively an affordability argument. Again, that argument is rejected by the court, paragraph 64. They say that participation in a public contract presupposes an appropriate economic and financial capacity. Now, that kind of hypothetical reasoning as to resources, actually in the Strasbourg case law, an individualised level is something that the court isn't particularly happy with. But nevertheless, the CJU is taking a fairly robust approach here. They say, no, actually, it doesn't matter that somebody can come to the court and say, we are in a parlous financial position. They say, no, we're happy to proceed on the hypothetical assumption that essentially a business that's tendering for that kind of work should have enough money for this fee. And then in paragraph 65, we see them place some weight on the fact that, as a rule, the unsuccessful party is required to reimburse the court fees paid by the successful party. And we do accept that's a relevant factor. And I would also say, if I may, that my Lord Newburger's question to my learned friend Mr. Ford in respect of the part of the Advocate General's opinion in which he refers to social policy, asking whether that had been followed by the CJU, was particularly on point, because the Advocate General's comment in respect of social policy was in the context of considering financial capacity. And he says, I think it's irrelevant that you get your fee back at the end of proceedings, because I think that it's very important that even if you lose, you should be able to bring the claim. And the court says, no, it's not irrelevant that you can get the fee back at the end of proceedings. In fact, that is one of the few relevant factors it picks out. So that's my hop, skip and a jump through Horizonte. Turning then to Star Storage, which is at tab 35. So it's a slightly different kind of measure that's before the court in Star Storage. This is a good conduct guarantee, which is paid to the opposing party in public procurement litigation. It's sizable. It's set at 1% of the contract value, but it's capped at €100,000. So it's a significant amount of money. But the purpose of the guarantee, because it goes to the other side, it doesn't go to the state. It's totally different from a court fee in that respect. The purpose was to discourage vexatious litigation. And in fact, the Constitutional Court had held that the provisions in the relevant domestic legislation which allowed for the guarantee to be retained at the end of proceedings were unconstitutional because they weren't limited only to cases where the litigation was vexatious. So they struck down, the domestic court struck down those provisions dealing with retention, and we were left with a position where the claimant pays the guarantee up front, but then automatically, whatever happens to the dispute, gets it back at the end of the dispute. So it's quite different, really, from a court fee. But nevertheless, at paragraph 49 of the court's judgment, which is page 2929, we usefully see the endorsement of Advocate General Eleanor Sharpston, saying that in a case such as this, when you're dealing with a precondition for getting any challenge examined, which must apply, we say, as well to a court.
The paragraph, sorry?
49.
Thank you, I have it, yep, thank you.
2929.
Yep.
That you apply what my learned friend would say, an orthodox proportionality assessment. Now, that does depart from the position in Horizonte, and we'll see later, although they cross-refer to Horizonte for one proposition, the court doesn't acknowledge that the structure of the assessment it's applying is different. So we see in paragraph 53, the court looks at the objective and endorses the objective of combating the abuse of remedies, this vexatious litigation point. And at paragraph 61, so I should say it spends some of the analysis considering whether post the decision of the Constitutional Court it could still be said to meet that objective at all, basically, because it's been stripped of a lot of its power. Then paragraph 61, it looks at the setting of the fee at 1% of the value of the public contract. It says it remains modest, in particular for tenderers, which must normally demonstrate a certain financial capacity, and there it cross-refers to Horizonte. So again, we say we have a focus on presumed financial capacity, on affordability, ability to pay in the language of Strasbourg in this case.
And what the Advocate General said at 37 is broadly approved. Is it worth going back to what she said at 35, Ms. Wakefield? On 2910?
Yeah.
I mean, she couldn't really have been clearer, could she? And you'll have to put this in the relevant context and seek to distinguish it, that we're not just dealing with practical impossibility or excessive difficulty.
Well, of course, my lord, and that same point applies to Horizonte, of course. It was the same article of the same directive. They're both public procurement cases, and directly analogously to the sex discrimination directive, which had its Article 6 requiring remedies to be put in place. In the public procurement regime, Article 1 of this directive, Directive 89/665, required that there be national remedies in respect of public procurement wrongs, that they be efficient, that they be swift. There's also a requirement as well about standing of people who can bring those claims. So we would agree that that's part of the broad context of EU law, and we see in Horizonte in particular how little it changes the analysis. So again, I would say that's in my favour.
So what is it about the public procurement context that requires this broader and possibly secondary analysis?
So if I could just, I imagine it would be set out, yes, in paragraph 3 of the judgment, which is 2921, that sets out Article 1 of Directive 89/665, and the third indent of the first paragraph says Member States shall take measures necessary that, as regards contracts falling within the scope of Directive 2004/18, decisions taken by contracting authorities may be reviewed effectively. So it's the same, in a way, it's breaking from the presumption of national procedural autonomy, because it's where there is a specific EU law rule that you then give effective force to, I suppose. And that was definitely in the minds of the court in both Horizonte and Star Storage. And nevertheless, the court fees in those cases were given the green light, despite the fact that in Horizonte there had been a significant deterrent effect. And despite the fact that the National Referring Court had been so concerned by that and by the point of the rational litigant, they had referred the matter to the CJEU. In closing, I'd like to just say a quick word about COOT. So COOT was relied on by the Commission in their written case, and like various others of the cases of the Commission adopted by Ms Rose yesterday. And I think it's relied on to say essentially that there should be a more intrusive standard of review than applies normally, or that even I think Ms Rose sought to rely on it to say there should be some kind of deterrence test. Mere deterrence might be enough. Of course, COOT, I'm not going to turn it up again, but it concerns the impossibility, the absolute bar, on an individual challenging her former employer's refusal to provide her with a reference after the end of her employment, where that refusal was believed to be in retaliation for having brought an earlier tribunal claim for sex discrimination, and she was therefore left without any remedy for that wrongdoing. Now, we fully accept that one of the reasons why the CJU held that member states were obliged to introduce into their national legal order a measure which was necessary to enable all persons who consider themselves wronged by failure to apply to them the principle of equal treatment, a remedy to pursue their claims by judicial process, which is at page 2744. One of the reasons was to ensure that workers weren't deterred from pursuing their claims because of a fear of subsequent retaliation, which was immune to judicial control. It shut down that particular loophole in the domestic procedure. However, we do not accept that you can take from that case that the proper standard when looking at court fees is one of simple deterrence. We say that the cases that are more direct on point simply don't support that proposition, and it's just selecting a word out of that judgment and placing on it far more weight than it can bear. So, in conclusion, then wrapping everything up, we say that the various factors set out in DB relate to legal aid. That cocktail of factors can't be transposed to our case. We say that Horizonte and Star Storage, of which Horizonte is by far the more on point, look at affordability. Horizonte does not apply the standard proportionality test that's urged upon you, and nevertheless believes itself to be complying with Article 47, gives the green light to fees which have that deterrent effect, and where the National Court thinks that the rational litigant would be put off, at least on occasion. So we say none of those cases support the submissions that the amount at stake, the importance of the right at stake, the deterrent effect of the fees are relevant. And we say that those cases tell us what EU law requires. They tell us what Article 47 requires, but also to the extent that they dip below what Ms Rose would say Article 6 requires, they tell us what Article 6 requires. Because we know that EU law on Article 47 can go no lower than Article 6. And those are my submissions, unless I can help you further.
Thank you very much, Ms Wakefield. Thank you.
Having dealt with the first two strands of law, which are relevant to ground one, I'll deal now with the third one, the common law. The only case directly on point in relation to court fees in my submission is Witham. And the facts of that case are almost the exact opposite of the current case. It involved a remission system with an exceptional circumstances discretion having been withdrawn so as to leave the claimant who was in receipt of income support and many other people absolutely barred from justice. It's thus a prevention case, and the ratio was that the claimant was absolutely barred from justice and his right of access to the Queen's courts had been violated. And if we turn that up, it's at Authorities Bundle 1, tab 9. And following the internal pagination, if we could go please to page 586. Towards the bottom of the page,
yeah.
and just below letter E, the paragraph that starts "in my judgment." Might I invite my lords and my lady to read that and to note particularly the second half of the paragraph and the reference to denial.
It would help to have a
2312.
2312, yes.
Forgive me.
Makes it quicker to get there.
Can't win, can you? Give one, you want the other. But we better have both. Thank you.
You'll be well on your way to winning if you give the MS number first.
I shall strive harder.
You're bound to upset some members of the court, whatever you do, in terms of order.
Oh, the authorities all have the MS numbers.
They do. Yes, that's right. My lady's right. The authorities all have the MS numbers. It's only the appendices.
It's the appendices that are the problem. So having sorted that out, what did you want us to read?
The paragraph at 586, E to G, the one that begins "in my judgment."
Yes.
The test that was applied there was one of denial. It's true that in that case, Mr. Justice Laws, as he then was, held that the domestic law provide no lesser protection than the Convention. And on our understanding of the Convention, we certainly don't disagree with that. Although we would point out that it's quite an old case and it predates all of the Strasbourg cases that have been referred to you by us this morning. We would add our submission is simply that the Strasbourg law doesn't assist the appellants. The other common law
is that the case is decided on its facts. It appears there's very little about the facts, but the proposition, which appears to be accepted, is he cannot afford fair fee. So, not surprisingly, the language meets that situation.
And doesn't test the question currently before the court.
Yes.
The other common law case cited by Ms. Rose was Leach, which I've already addressed. We say LPP and its potential abuse by prisoners is an entirely different factual scenario, and it's not a proposition from which one can extract a structured proportionality test applicable at common law to the current position. Turning to the more recent cases, Kennedy and Pham, although of course...
Are you not dealing with Hillingdon?
Yes.
You are dealing with it.
Yes.
Let's not forget, the local authorities could, obviously, pay the fee, the increased fee, but that was not the end of the story.
Yes, my submission again is that Hillingdon is to be distinguished. It obviously concerns public law, childcare and placement applications. In the material part, it's a rationality challenge, and it doesn't turn, in fact, on the financial issue because the authorities were being provided with, as the court found, more than the necessary extra funding. That's at paragraph 68.
So it was a wider question about deterrence.
The question was whether it was rational for the Lord Chancellor to impose a measure which it was alleged would have the effect of preventing public officials from doing their public statutory duty to protect children. And on the facts, it was overwhelmingly rejected. And it was simply because it was a rational decision in the face of the evidence which showed that overwhelmingly the officials would, unsurprisingly, comply with their duty to protect children, the authorities having been provided with the money. I submit you can't extract from that support from the proposition that a structured proportionality assessment should be applied.
Were they provided with the money irrespective of whether they used it? Was it just a lump sum which was given them on the basis they're likely to use this amount?
Let's turn it up, my lord. It's at tab 12 of volume 1.
2349 is the beginning.
And I'm looking, first of all, for paragraph 68, which is at MS 2370.
Just seems to have been an outright grant.
Yes, so it wasn't made, the funds weren't provided specifically for this function.
Hypothecated, no.
But the finding in the third line, starting in the third line of paragraph 68, indeed, it is likely to be more than is necessary to compensate local authorities as a whole for the extra costs of the fees. That was the finding in relation to the finance, and the finding in relation to the overwhelming evidence of continued compliance is at paragraph 71.
I think the answer to Lord Mance's question is in 69. It was some winners, some losers, but overall, nobody suggested that that the finances were going to operate as any kind of deterrent. Find that from 68.
Do they tell us why? It sounds as if it was a simple interdepartmental budgetary thing, that it increased the resources available to the justice system and decreased those available to the Department of what's now Communities and Local Government.
That is a question which I can't answer off the top of my head.
It seems relevant to know why they did it.
May I come back to you if we can find the answer to that, my lady?
Thank you.
So turning to the more recent cases, Kennedy and Pham, Pham, of course, being obiter dicta of the highest order of persuasion, would indicate that the common law doesn't provide a lesser standard of protection than provided by the other sources of law which we have been considering. And we don't disagree with that, but what we say is when one looks at those other sources of law and sees the standard of protection there, it's not the one contended for by the appellants. And what in truth they're trying to do is to persuade you to apply a structured proportionality test to the deterrent effect which the fees have had. And that, we submit, is not the way that these questions about court fees have been dealt with in practice in either Strasbourg or in Luxembourg. And she's also seeking to tempt you away from whether the question is that access to justice has been prevented, and move you on to the ground of whether access to justice has been deterred, and if so, whether that deterrence is proportionate. We respectfully submit that that is the wrong approach. Having summarised the Strasbourg jurisprudence, we submit that the approach is that absent some other special factor in the scheme or obstacle in the system which prevents access to justice, a proportionate fee is one which is affordable. The consequences of the approach to price sensitivity, which was advanced on behalf of UNISON yesterday, are also significant. Not only do we say that it's the wrong approach in law, we also say that the practical consequences of following this approach would be significant. The argument was raised for the first time yesterday. If it had been raised earlier, we might have been able to provide you with some more formal evidence. But the instructions I've taken overnight are that it's extremely difficult indeed to model this type of price sensitivity. And that would mean, realistically, in practice, the response would have to be to alter fee levels and test to see what happens. So the premise would be you would lower fees to see if that, in fact, increased your income, and presumably, if it didn't, you might then try to increase fees to see if that increased your income, a way of economically rationalizing and maximizing your income. That approach would have to be applied to all fees in all jurisdictions if, on my learned friend's analysis, the Lord Chancellor were to be in a position to prove that the level of fees was justified.
Mr. Barr, you did say in paragraph 126 of your case, the higher the fee, the more effective it is. Do you want to qualify that now?
There's no evidence that the fees that the Lord Chancellor has charged have gone past the point of increasing return. The statistics that my learned friend relied upon yesterday showed an 8% difference between the drop in claims between Type A and Type B, effectively from early 60% to late 60% drop. It's worth bearing in mind that the difference in level of fees between those two levels is a factor of 3. So fees which were 3 times more expensive than the Type A fees have led to an early 60% drop in claims. That's assuming that fees alone are in the litigant's mind, which is itself a question and one of the reasons why analysis is so complicated. But if you only get an 8% greater drop in claims on a 3 times difference in fee, that does begin to suggest that the price sensitivity relationship isn't a simple one. There is, I'll come to it in due course, some mention in the ACAS report of the sorts of factors people gave for why they didn't proceed to the ET, which further suggests that this is actually quite a complicated relationship. So I don't make any concession. It is a complicated discipline. We haven't had the opportunity to put in evidence about it, and we submit that at a level of principle, if the test is for the economic maximization of the system, that would have all sorts of ramifications. We submit at the lowest that it's open to the Lord Chancellor to take the alternative approach to reviewing the impact which the system has had and deciding that a better way of testing and adjustment is to alter the remission system, which is designed specifically to target those people whom we might assume are having to give up the greatest proportion of their disposable income in order to bring a claim.
So just as you and you're perfectly entitled to stick by what you said, just as you stick by what you said, the higher the fee, the more effective it is. You're talking about raising income for funding the tribunal. Just as that's your case, so can we take it that that is the theory which has informed the whole system?
I don't think I'm going so far as to say that you couldn't posit examples in practice where you could charge a fee that is so great that you would end up not just with diminishing returns, but with a U-turn in return. So I'm not saying that as a matter of principle. I'm simply saying there's no evidence on the fees that are being charged in this system that that point has been exceeded.
No, but was the alternative ever, was it part of the, is there evidence, I should say, you can't answer it, but is there evidence that the elasticity of demand point, if I may so call it, was ever considered
yes.
and rejected?
elasticity of demand point, I can take you to it when we go through the consultation. The short answer is that the government had available to it a 2007 study from the Ministry of Justice about based on a survey, I think, about price sensitivity of claimants in civil courts. The result of that survey was it wasn't thought that they were very price sensitive. And that is one of the reasons that the assumption in the at the outset of the scheme has turned out to be inaccurate, because there has been considerable price sensitivity.
Mm.
It may have been a rather unlikely extrapolation. If you look at the difference in order of fees between ordinary civil courts and the employment tribunal.
On that point, my learned friend only put in front of you the fees for a small track case. And there are, of course, much higher fees for the fast track and for the multi-track.
These are small claim fees.
Yes, and of course the small claim fees are such that they apply only to cases with a value of £10,000 or below, yes, which are not complicated and are going to be dealt with very shortly. The fast track is up to £25,000 in value for cases which are not expected to last for longer than a day and which are not especially complicated. Everything else goes on to the multi-track. So by analogy, any claim in the employment tribunal that's listed for more than a day is straight into the multi-track. Anything with a complicated issue, which of course are in abundance in discrimination law, for example, will be in the multi-track. The fees to issue a claim and I'm going to take you to the point where the court fees overtake the employment tribunal fees. The issue fee for a claim between £5,001 and £10,000 is £455. Above
That's fast track or multi track?
That's just what you have to pay if you issue a claim.
Or a claim between.
Wait a minute.
That's not the small claims track.
No. It's either fast or it'll end up either fast or multi.
That's slightly different from the figure in the last box on the note provided by Miss Rose and Miss Mona, and they say 410.
I have been handed this note this morning. We do have a copy of the current white book. I can check that. Above £10,000, which of course the medium level for discrimination claims is now above that, is 5%.
Right.
The allocation fee, which rolls up, covers a hearing, in the fast track is 545, and the fee for a multi-track is £1,090. So as soon as you move into the higher value and more complicated claims, or even the longer claims that are going to take more than a day, the fees escalate rapidly. And one of the downsides of a system which is based on charging fees by value, apart from the difficulty valuing them in the first place, is that the more valuable claims, for example, the discrimination claims, become a lot more expensive.
Is that a convenient moment?
It is, my lord. Thank you
very much. Court's adjourned. We'll resume again at 2 o'clock.